Okay, maybe we'll delve into the Statute of Enrollments, Wills, and the Abolition of Tenures. Now, the number one primary purpose of English law is, now we just want to get this, continue to be a repetitive thought or realization within your own mind so that you start to imbibe it and get to the predominant truth of what English law is. English law is, for greater certainty, agreements to the use of land subject to everyone performing an obligation under a right to a tenancy, which is all under this agreement. Agreement to be recognized with a right to English law. Okay? Now, the videos immediately before this one discussed that, the Cestui Act of 1707, unlike the one discussed in 1540, as we learned, that addressed potential loss in rent after the death of a tenant, and the 1666 Act, which addressed the interest of the life tenant, a lesser estate to the legal interest held in inheritance and common law, and so made determinable a right of reversion in the Lord if a tenant did not return to manage their estate after 7 years' absence. And then the 1707 Act, we learn, deals with the concealment of the death of a person holding a lesser estate, which, like I stated, we are only concerned with the reversionary attached to this estate interest, whereby this lesser estate, once annulled by the death of the tenant in possession, returns to us, the grantor, the settlement of that equitable interest. Now, before we go into the 1688 Bill of Rights, I will just make mention of a few other acts and statutes established in between that time of the 1540 and 1688 Act, only to make mention, but not to make it a requirement to our right of reversion. Enrollments 15, or the Statute of Enrollments 1536, we begin, in which, like many statutes before and after, appears to be stuck in competitive reasoning as to why the statute was effected in the first place. So because the origins of reasoning are in conflict, means that they serve no real purpose other than to offer up an opinion from those who dare to write about the statute's history. Now, it's important for us to realize that a matter of debate about history only serves to entertain the minds of historians, not what the law pays attention to, and so not a concern regarding what we are intentionally doing, which is making our intent known. Statute of Enrollment was described by one legal historian, who concludes that the enrollment scheme was written before the promulgation of the Statute of Uses 1535, and others surmise it was a quick fix remedy concerning a subsequent defect arising from the Statute of Uses and the conveyance thereof, through the practice of bargain and sale. And so the practice of this bargain and sale of the new conveyance created by the Statute of Uses, namely to prevent oral agreement arguments and to also serve as a means in which, for the benefit of the king, could establish a tracking mechanism concerning the number of the freeholds, so that he can keep track of what the freeholds were versus the use, and which he then had a right, or common law right, against those incidents, wardships and marriages and such. Now, as stated in the Harvard Law Review article entitled "The Political Causes Which Shaped the Statute of Uses," quotes this: Parliament declined to consider a general registration and passed instead a short act, supplemental to the Statute of Uses, to deal with those bargain and sales of freehold interest in land which the Statute of Uses had converted into conveyances. This ingenious conveyancer had not much difficulty in evading the obligation of enrollment imposed by this makeshift piece of legislation. The statute had no preamble. Statute of Enrollments, which legal scholars attributed to the reason, such as Lord Edward Coke, it being merely a proviso to the statute of uses. So no need to get into this, but to just point out that it was created in order to have a general registration concerning the enrollment of covenants, contracts, bargains, or agreements made with reference to the uses of lands. And so it's quite clear that the actual statute and the one for enrollments were integral parts of Henry's scheme for dealing with the use, so as to assist in the replenishment of his purse through the securing of his common law land interest. Now we move into the Statute of WILLS, 1540, an act later to be coined by the Hudson Star Chamber 69, which tells us that he, referring to Lord Ellesmere in this point, said that the Statute of Wills was not only the ruin of ancient families, but the nurse of forgeries, for that, by color of making wills, men's lands were conveyed in extremity of their sickness, when they had no power of disposement of them. Essentially, that's unquote there. Essentially saying, as landowners of great, long-standing ancestral estates became ill, some mentally incompetent, the vultures showed up to lobby for a will to be made in their favor. The 38th year of Henry VIII concerning wills is essentially a means in which to control the conveyance of land, and this is a quote from the freedictionary.com, by the landowners who, before the statute, did not have a right to determine who would become the new owner of the land upon their death. The inheritance of land in common law was dependent on whether the deceased landowner was survived by a competent relative or descendant. Generally, if a landowner died with no relatives, the land reverted into possession of the crown. The reversion was also called escheat, unquote. That noise in the background there was just snow sliding off my tin roof onto the second roof. So you get a little bit of a jolt once in a while. But as you see, I didn't jolt too much, so I'm pretty much used to it. The Statute of Wills made it possible for a landowner to decide who would inherit the land upon his death. At this time, approximately 2/3 interest was now in control of the person in possession to will at his own pleasure, and so not subject to the strict limitations of the common law interest of inheritance in fee, life, or entails. And that 1/3 then was given in right to the king. And like every other development in land laws, as before stated, and unlike the Roman civil law that the French just copy and pasted into their society, was a result of the kingdom responding to issues arising from land use, as they arose concerning men who wanted to control more rights in the conveyance of the land interests they had currently held, and so labored upon for the benefit of themselves and the kingdom. So just bottom line, men just want to control more interest, which is just common sense. We all do, right? English laws were dominantly created through natural evolution, evolving through a reactionary device as opposed to a proactive stance, or so does it appear. Now let's move into the Abolition of Tenures Act 1660. We can pretty much read it to get pretty much read right from the act itself to get right to this point, to which most of you have already done by the very mention of the title. Let me just move into the act itself. Just wait until it comes up. Here we go. The Tenures Abolition Act, 1660, Chapter 24, the 12th year of Charles II. And so we go, reasons for the passing of this act. It reads, whereas it has been found by former experience that the courts of wards and liveries and tenures by knights serve either of the king or others, or by knights serve in capite or in soccage or soccage in capite of the king, and the consequences upon the same have been much more burdensome, grievous, and prejudicial to the kingdom than they have been beneficial to the king. And whereas since the intermission of the said court, which had been from the lower and 12th day of February, which has in the years of the Lord 1,640 and 5. Many persons have by will. Maybe it's not 5, maybe it's S, but it doesn't make any sense. 5 or S. 5? No, it doesn't make any sense. 40 and 5, many persons have by will and otherwise made disposal of their lands held by knight service, whereupon diverse questions might possibly arise, unless some seasonable remedy be taken to prevent the same. Yeah, that's Old English for you. It's very flowery, you know. And it goes on, all tenures to be created by the king hereafter to be in free and common soccage. And there it is. That's the abolition. That's the purpose of the Abolition of Tenures Act, to go and move into the realm of free and common soccage, which then allows the wills and enrollments and everything else created after to have effect. Okay? And it reads, and that all tenures hereafter to be created by the king's majesty, his heirs or successors, upon any gifts or grants, or of any manors, lands, tenements, or hereditaments, of any state of inheritance at the common law, shall be in free and common soccage, and shall be adjudged to be in free and common soccage only, and not by knight service or in captive, and shall be discharged of all worship value and forfeiture of marriage, livery, primercision, ouster lemaine, okay, I'm not going to say that because that's a bunch of French words, and any law, statute, or reservation to the contrary thereof, any wise notwithstanding. Now, as I've mentioned before, we have to stand under the Norman Conquest. We had, before that, we had it's sort of the Dutch and German language predominant. The church brought in the Latin or the Roman language, and the William the Conqueror brought in, of Normandy, of course, brought in the French language. So those courts, the kings of the court, were predominantly set in French, and they didn't sort of all coalesce into English, I guess, until after the Protestant Reformation by Martin Luther against the Catholic Church, and we started moving into more what's where I'm looking for, transcribing everything from those languages all intermingled into one common language, being that of the English. Okay, let me return back to what I had written here. So, all fees, bottom line from what I read. So all fees relating to the reason one is held in tenure, mainly in which the tenure was created in the first place, and so continues since William the Conqueror's overthrow, were all now to be considered under free and common soccage, the means in which all land is used as a tenant today. So everything that government uses in Parliament is in free and common soccage. Now, does that mean there's no longer barons and lords who hold large tracts of land, perhaps through device of patents? No, there's no abolition of their tenures, inasmuch as they're moving to free and common soccage. They are now all just settled in common law under the device of that instrument that I've already referred to. Now, what does free and common soccage mean? Well, that's when we now move into or arrive into the Glorious Revolution. That was the settling of all the issues that arrived and sort of now amassed into that one area, one area that needed to be settled, so that men could actually have rights that were not governed completely under the will or our despotic monarchy, if you will. Okay, and let me just look at the time here. Where am I? 14 minutes. Well, let's stop here, and I'll create another video on the 1688 Bill of Rights, for that is a major transitional document for the reasons that I'll discuss in the next video.